Welcome to the Deep Dive, where we cut through the noise and deliver the essential insights you need to be truly informed.
Our mission today is a serious one. We're launching an investigation into a really profound and often, frankly, painful collision that's happening right now in Western democracies.
And that's the tension between religious freedom on one hand and the state's absolute guarantee of equal rights under civil law on the other.
Exactly. We're zeroing in on the function of Islamic Sharia councils, mainly on British soil, and what their very existence tells us about huge concepts like legal sovereignty and cultural integration.
We're going to be diving deep into a whole range of source materials today. We've got formal British government reviews, dense legal commentary, and some fascinating, really detailed ethnographic studies from the UK, the US, and even Scandinavia.
And the central question we have to answer, it's critical to the whole idea of a modern state. How do these informal faith-based dispute bodies, which critics very aggressively call a parallel legal system, how do they interact with, or maybe fundamentally collide with, established civil law?
When you hear the term Sharia council, I think a lot of people imagine something really monolithic, maybe openly hostile to the state.
Right, but the reality is so much more complex. And as you said, heartbreaking. We're looking at unofficial community-based bodies.
And they're issuing rulings on the most personal things imaginable. Divorce, child custody, inheritance, and the immediate shock factor, the thing that raises red flags for any human rights observer, is who's actually using them.
The data is completely clear on this. The applicants are overwhelmingly women.
Overwhelmingly.
That fact right there, that these councils primarily exist to serve women who are seeking a form of religious freedom, that is the central paradox we have to unpack.
So the controversy isn't that people are religious, it's about how these councils apply certain legal standards, especially around gender roles.
Which critics argue very forcefully fundamentally compromise core democratic values. Values like gender equality and that big principle of one law for all.
And this concern was so strong in Britain that the Home Department, the government itself, launched a formal review back in 2018.
And the reason for that review, stated in the official documents, was precisely because Sharia councils were deemed discriminating against women.
That immediately sets the stage for a truly investigative deep dive. We need to get past the political headlines.
We have to. We need to understand the institutional reality, the specific legal gray areas, and the very real human cost of what happens when women get caught between their religious obligations and their secular rights.
Our goal is to give you, the listener, a clear, impartial map of this complex system so you can grasp not just what is happening, but why it continues to happen. So let's start with the hardline legal position.
Okay.
So let's nail down the absolute legal status right at the very start. Officially, the UK government is completely unambiguous. Sharia councils are definitively not courts.
Not at all. Their decisions are not legally binding, and the official line is that Sharia law has no jurisdiction in England and Wales.
That seems crystal clear. So if the law is that clear, why on earth does this controversy just keep flaring up?
Because of the massive gray area that exists between that formal jurisdiction and the practical, real-world legal effect.
An effect that's actually enabled by UK civil law itself.
Exactly. While they can't operate as state courts, they do operate as a form of alternative dispute resolution, or ADR. Think of them as mediation bodies.
And the UK has a mechanism for this, a legal framework for private arbitration.
A very robust one. It's the Arbitration Act 1996.
The Arbitration Act 1996. Okay, can you walk us through the mechanics of that? Because that sounds like the legal loophole, or maybe the legal bridge, that gives these religious rulings some actual teeth.
It is absolutely the bridge. Under the Act, any two private parties can agree contractually to use any system of law they choose to resolve a dispute.
Any system?
Any system they agree on for private matters, usually financial or about inheritance. And that includes Sharia law. Now, once that arbitration is done and an award is made,
decision, yeah.
The decision, that award, is usually final and binding. And here's the crucial part. It can be registered with and then enforced by UK civil courts, like the High Court.
Wait, hold on a second. So if two people sign a contract saying they'll resolve, say, an inheritance dispute using Sharia principles, and a Sharia-based tribunal makes a ruling, the state the secular British courts, will then dedicate its resources to enforcing that religiously determined outcome.
Precisely. That is the nature of the Arbitration Act. It's designed to support commercial freedom, but it extends to these religious and private matters too.
So there are bodies that exist specifically for this purpose.
Yes, bodies like the Muslim Arbitration Tribunal, or MAT. Yeah. They exist specifically to use the 1996 Act for disputes. They operate explicitly within that framework, which means their decisions, once registered, carry the full force of a UK civil court judgment.
Wow.
So the state is, at the very least, indirectly lending its enforcement power to outcomes that are dictated by religious rules.
That immediately complicates the narrative that Sharia law has no jurisdiction, doesn't it?
It completely changes it.
And the proponents of these councils, groups like the Muslim Council of Britain, they often use a powerful defense against critics, right? They argue it's just a matter of fairness compared to other faiths.
That's the classic comparison argument, and it's highly effective in public debate. The argument is this: Jewish courts, known as the B'nai Din or Beth Din, they've operated in Britain for a long, long time,
providing arbitration and religious divorce, a get, for Orthodox communities.
Right. So the argument is, if the state accommodates and implicitly supports Jewish arbitration tribunals, then refusing to grant the same status or access to Muslims feels like unequal treatment. It feels like prejudice.
So critics who demand an outright ban on Sharia arbitration are essentially arguing for a ban on all religious arbitration.
Or they open themselves up to accusations of being discriminatory.
That's the political dilemma.
It is. In fact, the former Lord Chief Justice Phillips, he made this point years ago. He noted that private parties had already been able to use Sharia law under the Arbitration Act since 1996. It was already legally permissible, whatever the politicians were saying.
But the controversy is massively amplified by the actions of some of the councils themselves, isn't it? The ones that operate outside that formal Arbitration Act structure.
Yes, and that's where the confusion for vulnerable people really takes root. We've seen evidence that some of the less regulated bodies, they actually, and falsely, refer to themselves as courts.
With actual state-backed legal authority.
Yes. That misleading terminology is extremely dangerous. It preys on vulnerable applicants, particularly women who might not know English law that well.
And Baroness Caroline Cox, a leading secular critic, she specifically pointed this out in Parliament.
She did. She cited this deceptive self-labeling as one of her key concerns. It just blurs the line between a religious opinion and a state-backed decree, and that gives the council huge psychological and social power.
And even if the official legal status is non-binding, the social reality in some communities makes these rulings functionally binding anyway.
Absolutely. That is the critical point that you cannot miss. One commentator noted that these councils do enforce those rulings by the power of society.
So for a woman in a very tightly knit community, ignoring a ruling could mean what?
It could mean complete ostracization, threats, intimidation, being labeled an adulteress, or even a disbeliever. If a decision results in a complete collapse of your social world, its formal non-binding status on a piece of paper is completely irrelevant to you.
That social enforcement gives the councils real practical legal power.
It does.
And this tension between the secular law and the practical power of religious authority, it just exploded into the political mainstream back in 2008.
It did, with that really remarkable intervention by the former Archbishop of Canterbury, Rowan Williams.
He publicly suggested that some accommodation for Sharia law should be possible.
He did. He argued that Sharia isn't some alien and rival system, but just a sophisticated method of jurisprudence. He suggested individuals should be able to choose which jurisdiction they use for specific private matters.
As long as those choices respected basic human rights?
Yes, but that one suggestion just unleashed a national firestorm.
Why such a fierce reaction to what, on the surface, sounds like a call for moderate multiculturalism?
Because it struck right at the heart of the common law tradition. Critics were terrified that even the slightest state endorsement of a parallel system would fundamentally undermine the principle that all citizens are subject to one single, unified legal system.
And the government reacted fast.
Very fast and very firmly. The Prime Minister at the time, Gordon Brown, came out and stated that British laws must be based on British values, and crucially, religious law must always be subservient to British criminal and civil law.
And David Cameron, who was leading the opposition then, he echoed that stance. He rejected any expansion.
He was even more absolute. Cameron argued that allowing two laws to work side by side would be profoundly dangerous and would undermine society. He emphasized that non-negotiable principle: all citizens are equal before the law.
And that became the rallying cry of the One Law for All secular campaigning movement.
Exactly. The debate became intensely polarized, splitting politicians, campaigners, everyone.
And this sustained political pressure eventually forced the government's hand. Which brings us to that 2018 independent review into the application of Sharia law. What exactly was the mandate of that formal government investigation?
The mandate was investigative, and it was centered squarely on discrimination. It was set up precisely because, as we said, Sharia councils were widely deemed discriminating against women and potentially undermining the state's duty to protect its citizens.
And they looked at numerous councils and their practices.
Yes, looking for hard evidence of rights infringement.
And the key finding really confirmed the scale of the problem. What was the majority of their work focused on?
Overwhelmingly, the councils focus on Islamic divorces. We're talking over 90% of their casework.
And the vast majority of applicants are women.
Yes. The review found that this concentration of work comes from one central issue: the failure of couples to register their marriages civilly. We'll get into that in more detail. But critically, the review acknowledged there was evidence that the rights and freedoms of some women are indeed infringed in some proceedings by some councils.
And the review detailed specific bad practice, didn't it? Things that went beyond just, legal interpretation.
Yeah, absolutely. The bad practices they identified included things like inappropriate and aggressive questioning of women, insisting on mandatory mediation even in cases of domestic abuse.
Which is completely against standard practice.
Completely. And applying severe, sustained pressure on women to make financial or custodial concessions to their husbands just to get that religious divorce certificate. The review really highlighted the structural gender inequality in how these religious divorce procedures are applied.
So we see the debate splitting clearly. On one side, those who see these councils as a necessary service for immigrants and accommodation, and on the other, critics, secularists, feminists, ex-Muslims who warn this is a direct threat to the British Constitution.
A threat that promotes balkanization.
Right, that balkanization argument is a powerful one.
It's very forceful. The critics claim that institutionalizing Sharia councils encourages Muslim communities to live parallel lives, segregated and dislocated from mainstream British citizenship.
Which undermines the whole ideal of one common citizenship under one law.
Exactly. So this debate moves way past simple religious tolerance. It's challenging the fundamental social contract of a secular state.
Okay, we've hit on the central structural reason why these councils even exist in the first place. The crisis of the nikah-only marriage.
This is fundamental. If you don't understand this, you can't understand the problem.
So can we define this issue in detail? What is a nikah? Why aren't these marriages registered civilly? And what are the immediate consequences for the people involved?
Okay, so the nikah is the Islamic religious marriage contract and ceremony. A really substantial number of Muslim couples, particularly those with roots in South Asia, they undergo the nikah.
But they fail to follow through and register that marriage under English law.
Exactly. So the state, therefore, sees them as merely cohabiting partners, not married.
And what does that mean in practical terms for the woman if that relationship breaks down?
It means she has almost no statutory protection. Crucially, as you said, she cannot obtain a civil divorce because the state doesn't even recognize the marriage in the first place.
So no claim to financial relief under matrimonial law?
No inheritance rights, no property rights, no pension sharing rights. All the protections the state grants to legally married couples are just gone.
And this lack of civil protection, when you combine it with the religious obligations, creates this phenomenon that researchers call marital captivity, or limping marriages. That is such a powerful, dark term.
It's a very dark reality. A limping marriage describes a situation where a woman is legally separated or was never married civilly, but in the eyes of her community and her faith, she is still 100% married under Islamic law.
She's trapped.
She's trapped. Without that religious dissolution, the woman cannot move on. If she tries, she risks serious social and familial sanctions. She could be ostracized, labeled an adulteress. She could even face violence because her community still considers her bound to her husband.
So even if she just walks away from the relationship, she's still religiously and socially vulnerable. She has to secure a religious divorce to truly be free within her own social world.
Exactly. The lack of a religious dissolution means she can't properly remarry. She can't get the social acceptance she needs to rebuild her life. For these women seeking an Islamic divorce, usually through what's called a kula or a fasq, it is a desperate quest for freedom.
And it's not a rejection of their faith.
No, not at all. It's a necessary administrative step within their social field. The state can offer secular freedom, but that doesn't solve the woman's need for social freedom and religious legitimacy. That necessity is the profound raison d'etre, the whole reason for being, of Sharia councils.
And beyond the social ostracization, there are acute legal risks that can even cross borders.
Absolutely. Say the husband has ties to a country that operates solely under Sharia principles, like Iran. If the woman only has a UK civil divorce, or no divorce at all,
And the husband takes their children to that country.
her British civil divorce is unrecognized. She may lose all recourse to get her children back. And even within the marriage, the husband may feel he's still entitled to sexual intercourse, which is sanctioned by some interpretations of Sharia. And as we'll see, that is often weaponized as a form of coercive control and abuse.
This intense, unmet need for specialized religious services that the secular state just doesn't provide, it creates a specific dynamic that researchers have a name for.
They call it the Islamic juridical vacuum.
Tell us how that vacuum works.
Okay, the vacuum theory comes from research in non-Muslim jurisdictions like Denmark. It explains that where there's a clear and persistent demand for Islamic juridical services, like religious divorce, but no established institutional structure to meet it.
That demand just projects onto any available Muslim leaders.
That's it. It's actually very reminiscent of the UK experience back in the 50s and 60s, where you had these ad hoc religious bodies gradually emerging to handle the needs of migrants.
And when a respected Muslim leader, an imam or a scholar, successfully manages to issue an Islamic divorce without the husband's cooperation, a fasq or a kula, that success has what's called a cascade effect.
The cascade effect is crucial. News of a successful religious ruling just spreads like wildfire through community networks. And suddenly, that individual imam or scholar is temporarily transformed into a Qadian Islamic judge in the eyes of the community.
And the vacuum of demand gets directed entirely toward them.
They become flooded with requests, often way beyond their capacity to handle.
But this institutionalization is extremely fragile. You mentioned these temporary centers often collapse.
They do. The path to a stable institution is usually interrupted by resource depletion. I mean, one imam simply cannot handle the sheer volume of complex cases. Divorce is high-conflict, resource-intensive work.
Or they collapse due to security risks.
That's a critical factor. Dealing with angry, resistant husbands who reject the authority of the religious official issuing the divorce can lead to very severe threats. So what you see is these temporary institutions constantly emerging and then collapsing in this vacuum.
What's fascinating here, though, is that the women who are navigating this vacuum, they're not just passive victims, they are highly pragmatic agents.
That is a key finding of the ethnographic studies. The women view the councils pragmatically as an administrative means to their desired ends. They're looking for a stamp of religious authority and Islamic legal performance that will be accepted in their community so they can finally move on. They are strategizing.
And this includes what researchers call imam shopping, right?
Yes. They'll often approach different religious authorities with the same case. Maybe they'll tweak the details a little bit until they get the answer that best serves their goal.
The divorce.
The divorce. And the answer that aligns with their own construction of their rights. They're strategically using the council's authority against their own communities to secure acceptance of the religious dissolution. It's a desperate tactic, but often it's the only one they have.
This highlights a colossal disconnect between high-level government policy and the grassroots reality. And it's summarized by this idea of the epistemic ceiling. I find this concept intellectually profound. Let's spend a bit of time on it.
The epistemic ceiling refers to the level of policymaking, the top layer of the welfare state. This is where you get these zero collaboration policies being formulated.
Policies that instruct frontline state employees, social workers, housing officers not to cooperate with religious authorities.
Right. The theoretical ideal is complete secular neutrality.
But below that ceiling, on the ground, those policies are constantly being circumvented.
Precisely. Because the frontline workers know the policies don't solve the root problem of naked captivity. They are caught in a massive ethical dilemma.
Adhering to the official secular policy leaves their client trapped and socially isolated.
While breaking the policy, by collaborating with an imam, actually secures the client's freedom and safety.
So they choose pragmatism over procedure. What are some of the specific examples the research highlights about how these social workers bypass the ceiling?
Well, we see evidence of social workers secretly collaborating with imams, often using private emails or meeting outside of working hours, just to find a religious solution for the woman.
So they might pay the imam's fee out of their own pocket.
or use their own resources to connect the woman with an authority who is known to issue a FASC, a divorce without the husband's consent. They recognize that the woman needs both the civil freedom and the religious dissolution to be able to function within her community.
Wow. That is a massive indictment of that policy layer. It means Islamic legal practices below the ceiling have become an integrated, albeit hidden, part of how the state tries to manage these complex social realities.
Even if the officials above the ceiling ignore it or deny it, it shows that the state's positive obligation to protect its citizens sometimes requires pragmatic action that goes beyond theoretical secular neutrality.
The people on the ground recognize that ignoring the religious dimension is a form of abandonment for the women trapped in these marriages.
It's a powerful example of how legal pluralism operates in practice, regardless of the political desire for one law for all.
Okay, now we have to move to the very heart of the critique, the specific, deeply unequal procedures and practices within these councils that have caused the most profound alarm. We've already established that over 90% of the cases involve women seeking a divorce.
And the fundamental issue is the massive gender imbalance that is inherent in the pathways to that religious divorce. For men, the process is notoriously simple and unilateral. It's called talaq.
Explain talaq clearly for our listener. What is it?
Talaq is the man's unilateral right to divorce. Traditionally, it's enacted when a husband just announces his wish to divorce his wife, sometimes by simply uttering the word divorce 3 times.
Though modern practice is usually a bit more formal.
It is, but the power dynamic remains. Our source material explicitly highlights that this power is inherently discriminatory and is not a concept that we have in UK law. It's a direct conflict with the principle of mutual consent that's required for a legal divorce. The husband holds the religious key.
But for the woman, getting that same religious freedom is an entirely different and far more burdensome story. She seeks a kula or a fasq.
Her path is, as the sources say, far more onerous. A woman seeking divorce has to submit a formal application, and she typically needs one of 2 things.
Either the husband's agreement to the divorce, the kula.
Which often comes with conditions attached.
Okay.
Or she has to petition a recognized religious authority to dissolve the marriage on her behalf, the FASC, usually by citing grounds like abandonment or failure to provide.
So this asymmetry, a unilateral declaration for the man versus petitioning a third party for the woman, is inherently unequal. But it gets worse when you factor in the money motive.
That's right. There is significant evidence that some councils view this process as a commodity. They're criticized for prolonging the process, sometimes unnecessarily, even after a civil divorce has already been granted.
Purely to earn a fee.
Purely to earn a fee, which can be significant. We're talking up to £400 or even more per case. This turns a woman's quest for freedom into an unnecessarily long and expensive transaction.
And the worst part of that transaction is the pressure to concede. The councils are criticized for using the woman's desperation against her, coercing her into these unfavorable agreements.
Exactly. This is the core finding of the Home Department Review's bad practice section. Councils pressure women to make severe concessions to their husbands in exchange for that kula certificate, especially if the husband is being uncooperative or just malicious.
And the most common concession is waiving the mahr. What is the mahr, and why is waiving it such a major financial concession?
So, the mahr, it's often translated as a dowry or a nuptial gift. It's a mandatory payment or a promise of payment made by the husband to the wife at the time of the nikah.
And it's her exclusive property?
Her exclusive property. It's often meant to serve as a form of financial security, basically an insurance policy for her if the marriage ends. So if a woman is forced to waive the mahr to get her religious freedom, she's sacrificing her own financial safeguard.
So the religious authority is basically facilitating an exchange, religious freedom for financial security.
That is precisely how it functions in these high-pressure situations. Some imams who facilitate the process even admit they are helping the woman make the best deal possible, acknowledging that the woman is so desperate she's prone to accepting highly unfavorable agreements just to be released from the nikah.
The criticism escalates dramatically when we look at how these councils handle domestic violence and abuse.
This is where the investigative reports are just chilling. There's evidence of Islamic scholars actively downplaying serious abuse.
I remember the BBC Panorama investigation from 2013. It said Sharia councils were putting Muslim women at risk.
That's the one. One Islamic scholar told an undercover reporter that they should report domestic abuse to the police only as a last resort.
Only as a last resort. That contradicts everything the state advises about safety and criminal law.
It suggests an institutional objective to keep conflict contained within the community under religious authority, which could compromise the victim's immediate safety.
And we have some alarming quotes from council founders, too.
One was reported to have stated that men should not be questioned over why they hit their wives. And Qadi Sahib Hassan was filmed secretly on several occasions, downplaying the severity of violence and deterring women from going to the police.
It's a severe failure to uphold the woman's safety. It's treating abuse as a private matter for religious arbitration, not a crime for state prosecution.
And this extends into the realm of sexual violence, which challenges the very definition of marital consent that is upheld by secular law. This is where the conflict becomes irreconcilable.
It does. High-ranking Islamic scholars have controversially stated that marital rape is not an offense in Sharia because sex is part of marriage,
thereby legitimizing the husband's entitlement. Maulana Abu Saeed, the former chairperson of the Islamic Sharia Council, stated that classifying non-consensual marital sex as rape is not Islamic and a major aggression. He was referencing traditional Islamic jurisprudence that fundamentally differs from modern secular notions of consent.
That religious discourse must be an incredibly powerful weapon in a coercive control relationship.
Absolutely. Coercive control weaponizes religious discourse. Men will often insist that being sexually available is the duty of a good Muslim wife, citing religious texts and narratives.
And women who are dependent on their religious identity are so vulnerable to this.
They often feel compelled to endure the abuse and resign themselves to remaining sexually available to their ex-husbands rather than using penal law against them. They fear the religious and social consequences of resistance.
The process of divorce itself can be used to perpetuate control. You call it the weaponized talaq.
Precisely. The process of getting a religious divorce becomes another point of leverage for an abusive husband. The woman is desperate for that certificate to escape the social stigma and the marital tie, and he knows this.
So he manipulates the process.
He manipulates it, forcing her to agree to highly unfavorable terms, waiving custody, waiving dower, sacrificing financial claims, all in exchange for the one document she needs to regain her social life.
The gender discrimination we're discussing, it's not just limited to the divorce process. It extends clearly into financial and child welfare disputes. Let's look at inheritance.
Okay, in inheritance disputes, particularly those handled by the Muslim Arbitration Tribunal, the Amat Mahdi, under the Arbitration Act.
The decisions have to align with Sharia principles if that's what the parties agreed to.
Right. And the sources cite cases where, in accordance with traditional Sharia law, the men were given double the inheritance of the women.
That is a stark example of a discriminatory outcome being given state enforcement power through the Arbitration Act.
It's deeply troubling, especially when you consider the principle of equality under the law.
But what about child custody? This is where UK civil courts insist that the child's welfare must be the paramount concern.
And while the civil courts can't be ousted, child arrangements are definitively their domain. Sharia councils still issue rulings that try to impose religious norms.
For instance, the Islamic Sharia Council has issued rulings stating that a child must go to the father once they reach the age of custodial transfer,
which is around 7 to 9 years old for boys. And this is stated to be irrespective of child welfare rules.
Irrespective of child welfare rules, that's a direct challenge to the very foundation of family law in the UK.
It is a profound institutional conflict. The Sharia councils operate on a fixed age rule. They argue that a boy above 7 is no more in need of a woman's care. This religious determination completely ignores the individualized, holistic welfare assessment that is required by civil courts.
And the power dynamic created by the Nisa captivity allows men to use these religious rulings as attempted trade-offs in civil proceedings.
Yes, this is another insidious consequence of the system. There are reported cases where men attempt a trade-off. They'll offer the woman the Islamic divorce certificate she desperately needs, but only if she agrees to a custody arrangement that's favorable to him.
So he's trying to bypass or undercut existing civil court arrangements.
And because the woman's social freedom depends on that religious certificate, this leverage is extremely effective. It creates immense pressure to concede to terms that could be potentially harmful to the child's stability.
So we return to the foundational issue. Can a secular democracy accommodate a legal system that, by its very nature, appears incompatible with its core principle of gender equality?
The European Court of Human Rights, the ECTHR, has already weighed in on the theoretical incompatibility.
What was their view?
The court has subscribed to the view that Sharia in itself is incompatible with the fundamental principles of democracy. And the basis for that is largely the inherent infringement on the principle of non-discrimination, especially regarding gender equality.
And yet, the arguments for accommodation, the ones rooted in multicultural principles, are still very potent. They suggest that accommodating faith is vital to identity and integration.
That perspective argues that, for many people, having an Islamic faith is a vital marker for personal identity and self-respect. So therefore, accommodating an additional legal system, as long as it adheres to the rule of law, is justified as a matter of religious freedom.
And equality with other minority faiths, like the Jewish Beth Din.
Exactly. Proponents see Sharia not as some rigid, monolithic code, but as a method of jurisprudence that can be adapted and interpreted. They fear that banning Sharia councils would just drive the whole practice underground, making vulnerable women even harder to reach.
But on the opposite side, the One Law for All camp insists that this accommodation is a political and a constitutional mistake.
Critics argue that any state recognition or even toleration of Sharia councils just deepens women's dependence on these institutions. It strengthens fundamentalist voices within the community and ultimately weakens the secularization they feel is necessary for full integration.
They insist that Sharia is already functioning as a competing body of laws on British territory.
A body of laws that is fundamentally hostile toward women and non-Muslims. They warn that state oversight, even if it's intended to curb abuse, will just give the councils more credibility, legitimizing what they call a second-rate system of justice.
So the secular argument is that the state shouldn't be patronizing or complicit in underwriting a system that confines women's needs to the prism of conservative religious values.
Yes. They view this as a matter of preventing sectarian fragmentation, that balkanization we talked about. They contend that establishing even minimal Sharia jurisdiction risks enormously increasing the power of the mullahs and imams to push for further exemptions from secular law, thereby eroding common law principles. The political stakes are very, very high on both sides of this argument.
So given these extreme positions, the most pragmatic solutions seem to focus on addressing the structural cause, that unregistered marriage problem, rather than the councils themselves.
Right, get to the root of it.
What was the central recommendation of the Home Department review on this?
The primary recommendation was what's called the marriage law solution. This would require amendments to the marriage acts to ensure that civil marriages are conducted before or at the same time as the religious nikah ceremony.
This is already the standard for most Christian and Jewish marriages in the UK.
It is.
So how exactly would that solve the problem of marital captivity overnight?
Well, if all nikahs were legally preceded or instantly followed by civil registration, then every woman would automatically gain civil protection under UK law. She would have access to civil divorce, financial remedies, property rights, all the statutory protections the state provides.
Which would render the religious divorce certificate less critical for her survival and autonomy.
And it would strip the Sharia councils of their leverage over vulnerable women.
That seems like a powerful, systemic fix. There was also a legislative attempt to constrain the existing system, even for those already trapped, through the Arbitration Act.
That was the Cox Bill. Officially, it was called the Arbitration and Mediation Services Equality Bill. It was a private member's bill that tried to impose explicit civil rights requirements onto the Arbitration Act proceedings.
So the Cox Bill was trying to ensure that even if parties voluntarily agree to use Sharia law for arbitration, discriminatory rules like unequal testimony value or unequal inheritance could not be legally enforced.
Exactly. The intention was to make sure that if a Sharia tribunal applied rules that are deemed discriminatory under UK equality law, the civil courts could then refuse to enforce the resulting award.
Did it pass?
No, it was fiercely opposed by some religious groups and ultimately failed to pass. But it did highlight the legal necessity of addressing discrimination within private contractual arbitration.
And outside of Britain, other jurisdictions have looked at more aggressive ways to neutralize the leverage that husbands have in these marital captivity cases.
Yes. Places like the Netherlands have explored attempts to actually criminalize marital captivity.
So they would make it a prosecutable offense for a husband to refuse to grant a religious divorce.
To deliberately leave his wife trapped and unable to remarry religiously? Yes. The intent is to legally compel uncooperative husbands to grant the divorce, which would remove the woman's dependence on these lengthy coercive religious tribunals.
And finally, that brings us to the fierce debate: regulation versus abolition.
And this split is profound. Some Sharia councils themselves, recognizing the bad practice highlighted by the government review, they actually welcomed regulation.
They wanted to standardize procedures.
Yes, bodies like the UK Board of Sharia Councils were set up to standardize procedures, ensure fairness, transparency, and informed consent. They believe state oversight would eliminate the worst offenders and guarantee a baseline of fairness.
But the opponents see regulation as a disaster.
They argue that state legitimization is tantamount to state endorsement. Regulation would further blur the line between the state legal system and informal arbitration, giving the councils even more credibility and institutional strength within Muslim communities.
They argue it would empower the most regressive voices.
And strengthen the pressure on women to use these courts. For critics, the focus has to remain on ensuring women are fully aware of their superior rights under UK civil law, and above all, fixing the lack of civil status for nikah-only marriages. Regulation, they say, just entrenches the parallel system.
This deep dive into Sharia councils has revealed such a complex collision of identities, legal systems, and human rights obligations. What stands out to me is this persistent tension between the freedom to believe, which is absolute in any democracy, and the freedom to act, which has to be limited by civil law to prevent harm to others. When faith practices generate social and legal consequences that diverge so dramatically based on gender, the state's positive obligation to protect its citizens comes under severe strain.
And I think it's important to reflect on why this system emerged and why it persists. It's rooted in migration, in the failure of the state to initially recognize the needs of minority communities and the desire of people of faith to live under laws they consider religiously binding.
And the system of Sharia councils, paradoxically, persists because it solves a painful real-world problem, marital captivity, even as it perpetrates gender inequality.
Which raises an important question for you, the listener. In complex pluralistic societies where identity is paramount, how can the state fulfill its positive obligation to protect the equal rights and freedoms of all citizens without undermining the vital religious identity of others, especially when social and religious survival depends on community acceptance?
And let's also reconsider that epistemic ceiling we discussed, that vast, silent disconnect between high-level legal theory and the day-to-day, on-the-ground reality.
The fact that welfare professionals are often forced to secretly break policy to help vulnerable women escape captivity suggests a profound systemic failure.
When information about coercive control, marital captivity, and localized arbitration practices is suppressed or ignored or just misunderstood by policymakers, how does that silence contribute to the perpetuation of these parallel, unequal systems?
That's something profound for you to mull over this week as you navigate your own informed path.
Thank you for joining us for this deep dive.
See you same time and same place next week, and thank you for listening to the ETUK Podcast Show.
Yeah.